Landlords should now be thinking much more like asset operators rather than passive property owners.
Well, I think it's probably the biggest reform we've seen in the sector for about 40 years or so, including the loss of no-fault evictions, so no more rental bidding wars.
They should be paying close attention to the Renters' Rights Act 2025 because, as Chris mentioned, it represents one of the biggest changes to the residential tenancy law, and it will materially affect risk and compliance burden in the private rental sector.
England's rental market is changing fundamentally. In October 2025, the Renters' Rights Act received royal assent, which is described as the biggest overhaul of the private rented sector in decades. This new law reshapes how landlords let property, how tenants live, and how investors think about risk, returns, and regulation. Today, we will break down what the Renters' Rights Act is, why it matters, and what it means in practice for landlords and property investors navigating the UK market going forward. I'm lucky to be joined by Antonia Manti from Consulco Group's in-house legal team who advises investment managers and investors. Today, we also have Chris, who is a UK-based landlord and tenant law specialist. It's great to have you both here. Welcome. So, the first question I would like to ask Chris, just to start off, can you share a brief description of what the Renters' Rights Act 2025 is?
So I think for some time there's been a need within the private rented sector for additional regulation. I think this has come about because you do have rogue landlords operating in the sector, and I think there's been a feeling that some tenants have been treated unfairly as a result of that. New regulation will bring about, obviously, various different changes, whether or not it potentially goes a bit too far and will be detrimental to the honest, decent landlords who treat their tenants well within the sector, I think remains to be seen.
And why is it being described as such a major change to the rental market?
Well, I think it's probably the biggest reform we've seen in the sector for about 40 years or so. There are sweeping changes to various different aspects, including the loss of no-fault evictions. You've got restrictions on negotiations of rent as well, so no more rental bidding wars. And then you've got some additional provisions that they've thrown in as well as to what tenants can actually do with the property. So, for example, if tenants want to keep pets, then they're now entitled to do that as well.
Thanks for letting us know about the pet thing. I have a pet, so this is very valuable for me. I would like to ask Antonia the next question. Why should landlords and property owners be paying close attention to this new law?
They should be paying close attention to the Renters' Rights Act 2025 because, as Chris mentioned, it represents one of the biggest changes to the residential tenancy law, and it will materially affect risk and compliance burden in the private rental sector. So the Act abolishes fixed-term assured short-hold tenancies, or in other words, ASTs, and it replaces them with assured periodic tenancies that continue indefinitely on a rolling basis, typically month by month. This will essentially mean that landlords can no longer rely or offer minimum fixed-term contracts and will create uncertainty on the duration of those tenancies. And in addition, under the new regime, the tenants can terminate these rolling periodic tenancies by offering and serving 2 months' notice to the landlords. The Act abolishes Section 21 no-fault evictions, as Chris mentioned. So this will mean that landlords can no longer regain possession of their properties by serving notice under Section 21. However, they can still regain possession by following the grounds outlined under Section 8 of the Act. And it's important to note here that each of these grounds carry its own notice period and requirements. These changes will make the process slower, potentially more complex, and more costly when it comes to court proceedings.
Okay, so it sounds like the process is becoming quite a bit more complicated for them. What about from an investor's point of view? Why should they also be paying close attention to this new law?
This is quite interesting, as from an investor's perspective, the removal of fixed-term end dates and the abolishment of Section 21 reduces control over the duration of the tenancies and cash flow predictability. So this creates an increased need for adequate tenant screening and efficient ongoing management.
Chris, so Antonia just mentioned the Section 21 no-fault evictions. These are being abolished, correct? Can you explain what this means and how it changes the way landlords can regain possession of their properties?
I think landlords will generally need to be much better organised and need to plan if they do want to evict some of their tenants. Obviously, the Section 21 no-fault evictions has been used for some time when a landlord simply wants to gain possession back from the property. Now, landlords are going to have to rely on one of those prescribed Section 8 grounds. So in terms of the grounds that remain, there are still options for landlords to be able to get control back of the property if they want to move in or want to move a family member in, but they can no longer effectively just issue that Section 21 and clear the tenants out because it suits their interests. I think there's going to be much more of a need for landlords to be better in terms of their documentation and their retention of that documentation so that they can evidence certain types of behaviour. So, for example, antisocial behaviour is still one of the grounds for eviction, but the maintenance of that document record and that paper trail is going to be all the more important as well. I think the aims are still to balance the tenant's interests with the legitimate landlord's interests. Landlords are just going to have to be much more strategic in terms of how they go about obtaining that possession.
You mentioned the Section 8 grounds. Means that landlords can now regain possession only for specific reasons, such as selling the property, correct? Great. So rather than using the no-fault evictions, right? So, Chris, do you think that these new grounds are being practical and clear enough to protect the tenants while also allowing landlords to manage and exit their investments whenever they want?
I think there is more clarity around the grounds that are being offered now, which obviously from a tenant's occupation perspective is certainly beneficial for them. It gives them certainty that they've got the tenancy for a reasonable period of time, that they're not going to be sort of turfed out partway through a tenancy as they might have been previously, certainly in the case of rolling periodic tenancies, for example. But I think the balance will depend predominantly upon how those grounds are enforced and the ability of the courts and the tribunals to effectively deal with what is no doubt going to be a larger number of very precise grounds upon which landlords are relying to evict those tenants. And therefore, it's just going to require a much higher degree of organisation from landlords and pre-planning to make sure that those evictions are successful.
Chris, can you elaborate a little bit more on the Section 8 grounds? Because it really seems like it's such a big part of this new act.
Indeed. I think certainly something to bear in mind for the landlord. So the first two are either the landlord or a family member intends to occupy the premises for their own use. That one is subject to a minimum tenancy period during which landlords can't use that against the tenants. Similarly, if the landlord intends to sell the property, again, there's a minimum tenancy period during which that can't be exercised by the landlord. So landlords will need to think carefully about if they're intending to dispose of a property, whether or not they do want to grant that new tenancy, because it might prevent them from selling with vacant possession. Redevelopment or demolition of the property as well is another option for landlords if they want to substantially improve the property as well. And then where you move into the sort of the more problem tenant type grounds, antisocial behaviour is still there and is still a reason for eviction, as is non-payment of rent, albeit that the period for non-payment of rent now is 3 months. So landlords need to have that evidence again of that non-payment of rent, and that also has to be up to and including the date of the hearing as well. So query whether the savvy tenant might actually look to clear their arrears just before a court date, for example, to try and avoid eviction there. And then if there's enforcement action against landlord by a local authority, for example, that is also potentially another ground. So worth bearing in mind those slight changes and again that loss of Section 21 and the no-fault eviction when landlords are looking to obtain possession of the property.
Antonia, next question I would like to ask you from a risk management perspective. What should landlords be thinking about now that the possession rules are being more structured, transparent, and outcome-based?
So from a risk management perspective, landlords should now be thinking much more like asset operators rather than passive property owners. With possession rules becoming more structured, transparent, and outcome-based, compliance is no longer just a legal obligation. It is now a core part of protecting rental income and asset value. Landlords will be required to join the new Landlord Ombudsman scheme and register their properties with the private rented sector database, which increases transparency and accountability across the sector. This means that investors need to ensure their portfolios are properly documented, compliant, and audit-ready, as non-compliance can lead to penalties, reputational issues, and disruption to income streams. Additionally, the extension of decent home standard and EMW Law to the private rental sector places greater emphasis on proactive repairs and ongoing management, especially around damp, mold, and other heat-related hazards. For higher value and institutional grade assets, this reinforces the commercial importance of preventative maintenance and capital expenditure planning as a way to sustain demand, avoid enforcement action, and protect values. So in short, risk management in the new regime is about compliance, data visibility, and operational capability.
Now, the new act also introduces new rules around rent increases, bidding practices, and discrimination, right? So, Chris, I would like to ask you, what practical changes really will landlords notice most in their day-to-day operations?
I think even before they've got the tenant in the property, the first thing they're going to have to consider is the rental value that they actually want to let the property for. The changes in relation to the rent mean that effectively once you market the property, that rental income is fixed and landlord can't let the property at a higher rent than is advertised. Certainly the previous practice where you've got a very desirable area of potentially, if you've got more than one tenant interested, engaging in a bidding war to make sure that they secure the property, that's now going to be prohibited. So some clear advice, I think, to landlords in terms of the appropriate rental value before they market is going to be important. There are also going to be restrictions in terms of the types of tenants as well that landlords can let to. Landlords are no longer going to be able to refuse tenants either because they have children or they're on benefits, albeit that landlords are still able to consider income and affordability as part of their process. This obviously broadens the pool of potential tenants, but I think from a landlord perspective, they need to make sure that they're being fair and compliant in their processes as well.
Antonia, how might these changes that Chris just covered, how might these affect non-UK residents and landlords who may not be managing their properties directly?
So this is a really good question, actually, and we did receive some queries on this. Absentee landlords may face additional challenges as the new act places a greater emphasis on ongoing management, compliance, oversight, and tenant responsiveness. So there is a greater need of adequate asset management agencies that can handle compliance, repairs, and tenant responsiveness in real time. So absentee landlords will have to have reliable local arrangements to be able to manage and comply with their additional obligations.
Great. Chris, do you think that this new legislation will lead to a more professional and transparent rental sector, or are there still areas that may need further reform?
I think on the whole, the additional regulations will be clearer. They'll allow for a more transparent management process and interaction between the landlords and their tenants. The improved property standards and potential to refer to ombudsman all encourage more structured management, which is obviously positive, and they'll reduce the scope for poor quality landlords or unscrupulous practices for landlords for sure. This is broadly positive, obviously, for tenants, and I think it does offer additional clarity to landlords as well. But there is still that question mark as to the ability for the courts and tribunals to manage a certain volume of transactions or applications from landlords in relation to the new legislation. There are, I think, still some areas that will need to see additional clarity as well. So, for example, one of the grounds that landlord can use to regain possession of a property is the request to allow a family member to occupy the property. Family member isn't currently defined in the legislation, so there will no doubt be some additional discussions and negotiations as to how far we can extend the definition of family member, for example. So I think certainly the direction of travel is right. With successful implementation, I think it will be positive overall, and it will support that fair balance between tenants and landlords. But landlords obviously will have some more work to do to manage their investments.
Excellent. Thank you so much both for coming here today and sharing more information on this new act. It's been very insightful.
Pleasure. Thank you for having me.
Thank you so much for having me.